Can hearsay evidence be used against you in court? Imagine sitting in a courtroom and someone tries to tell the judge what you said outside of court. You might wonder if that statement can be used to prove your guilt. That's where hearsay comes into play. Hearsay evidence is when someone talks about what someone else said outside of court, and that statement is used to prove what actually happened. Usually, courts don't allow hearsay evidence against you in criminal trials. The reason is simple. The person who made the statement isn't there to be questioned or cross-examined. Without that chance, it's hard to tell if what they said is true or reliable. The main goal of the hearsay rule is to protect you from being convicted based on second-hand information or rumors. Courts want to make sure that the evidence used against you is solid and trustworthy. But there are some exceptions. Sometimes hearsay can be allowed if everyone involved agrees to it. This includes the judge, the defense, and the prosecution. Hearsay might also be admitted if it helps show something important, like whether you were at the scene of a crime. For example, if someone says they saw you there, but that statement is hearsay, it might still be allowed if it meets certain rules. There are specific types of hearsay that courts accept more easily, like excited utterances, which are spontaneous statements made during a startling event. Another example is statements against interest, where the person making the statement admits something that could harm them legally or financially. Even when hearsay evidence is allowed, it's usually not used to prove that what was said is true. Instead, it might be used to show what the person believed or their state of mind. This limits how much hearsay can influence the case. From a defense point of view, the hearsay rule is a key protection. It stops the prosecution from relying on unverified, second-hand statements. Defense lawyers can object to hearsay evidence, arguing it shouldn't be allowed because the person who made the statement isn't there to be questioned. This helps keep the trial fair and ensures that only reliable evidence is considered. If hearsay evidence does come in, the defense can challenge it by asking questions about how and why the statement was made. They can point out inconsistencies or argue that it doesn't fit into any of the accepted exceptions. This process helps prevent unfair prejudice and make sure the case is based on solid proof. So, in most cases, hearsay evidence cannot be used against you to prove your guilt. The law aims to keep trials fair by requiring evidence to be tested and verified. That's why understanding your rights and protections around hearsay is so important if you're ever involved in a criminal case.